Um, yeah, I'm here on behalf of the defendant, Jamil Lockhart, and they're making a special appearance.
All right, well, you got to make your special appearance to the Wayne County Jail. I told you that the last.
When the court called your case, you didn't step forward in the way the judge expected. Instead, you identified yourself using an unusual description, referring to yourself as Jamil of the family Lockhart, a living man made of flesh and blood, and claiming to act as an attorney in fact for the named defendant, Jamil Lockhart. Because of this, you did not personally appear on your own behalf, since you are not a licensed attorney permitted to represent anyone in court, including yourself in that manner. But interestingly, that wasn't the issue that ultimately caused the situation to escalate. The court is used to seeing unconventional statements from certain defendants, and it typically responds with clarification or correction.
Yeah, so I filed a notice of removal for all of these cases because I don't believe that this court is capable of acting in an unbiased way. But I mean, there's been no response from the city, up to this point. I mean, just the last court date we had, perjury was committed. I mean, you guys put on the record that I failed to appear.
When the court called your case, you didn't step forward in the way the judge expected. Instead, you identified yourself using an unusual description, referring to yourself as Jamil of the family Lockhart, a living man made of flesh and blood, and claiming to act as an attorney in fact for the named defendant, Jamil Lockhart. Because of this, you did not personally appear on your own behalf, since you are not a licensed attorney permitted to represent anyone in court, including yourself in that manner. But interestingly, that wasn't the issue that ultimately caused the situation to escalate. The court is used to seeing unconventional statements from certain defendants.
And I spoke to you.
You did fail to show up to the Wayne County Jail. You were ordered to do 30 days in the Wayne County Jail. You haven't showed up. You still haven't showed up. So you still disobeying. Let's not do this. This is how it started the last time. You're still disobeying the court's order, and you have to do 30 days. You have to present yourself to the Wayne County Jail. You have a warrant out for your arrest. And before we go over this other stuff, you got to go. You have to go to the Wayne County Jail. All right?
Yeah.
Okay, sir. So
I said what
I can increase the time if you can take to not be compliant.
Your Honor, I apologize for interrupting the proceedings. May I have a breakout room with this litigant, please, and thank you.
I don't know if he wants to speak to a lawyer, but he can if he needs to. He has that right to do so. You want to speak to the lawyer, Mr. Lockhart, or no?
Yeah, sure.
There's an old saying about guiding someone toward the right path, but not being able to make them actually follow it. Someone once mentioned it in this very context, the idea that you can lead a person to the solution, but you can't force them to accept it. And now that I think about it, I realize I was the one who said it. It fits this situation perfectly, because the court laid out every clear step needed to move forward. Yet the individual at the center of this case still refused to take the simplest action. That it's a reminder that sometimes the biggest obstacle isn't the system or the process. It's the person refusing to cooperate with it.
So I don't know why he's still sitting here.
Well, Your Honor, if the court will allow, we would like to attempt resolution of the matters that are on the docket. So I would ask if the court could stay the contempt proceedings and allow him to handle these matters.
No. It's been well over a year. No, he's gonna have to go turn himself in, and we'll deal with it that way.
Your Honor, if the court could, just in the interest of justice and judicial economy, if he could resolve these matters, if he's still gonna have to do the 30 days in Wayne County Jail, if at time of sentencing, it could all be wrapped up together, just to not further delay his constitutional right to speedy trial.
He's delayed his rights. He's delayed his rights to a speedy trial.
And I do have a resolution, Your Honor.
No, I don't want to. I'm not even going to entertain it. We're That ship has sailed. We tried to give him that opportunity a long time ago. He kept being contemptuous in the court. He comes with these far out legal theories that he has that I quite frankly, don't know where he's coming from on that. No, I'm not gonna even entertain that with.
And Your Honor, I completely understand the court's position. I completely understand if he still has to do the 30 days Wayne County Jail, but I think that he was potentially misguided, did not understand the finer points of the law, court rules, and courtroom behavior and procedure. So now that he has the assistance of counsel, which I'm not saying that he didn't have the assistance of counsel before, if the court would allow him.
We offered him counsel then. He denied the counsel. Go back and look at the video. It's got over 270-some thousand views on it.
It really makes you think, doesn't it? When he mentioned that video, it seemed like a subtle hint toward a very specific moment someone had captured. Almost as if he was indirectly referencing a clip that many of us might recognize, that it's hard not to wonder exactly which recording he had in mind, especially given how closely it aligns with what we're discussing here. Moments like this always leave you curious. Was it a coincidence or a deliberate nod to something we've all seen before? Either way, it adds an interesting layer to the situation, and the timing couldn't be more fitting.
Told him that 30 days will give him an opportunity to read up on the law, and so he can make it and understand how this process goes. So go ahead to the Wayne County Jail. You can take some. They probably have some legal books there. And we'll hear these matters when you come out, sir.
Your Honor, is any of this on the record or no? Or did we not? Okay.
No, it's not on the record because I didn't call the cases. I'm going to continue on. That appears to be Charles Gardner.
Yes.
Okay.
Yes.
Your Honor, am I allowed to go back in the breakout room to explain that to Mr. Lockhart? Because he seems to have had a change of heart if the court would allow him to at least.
Maybe he can go turn himself in and you can file an appeal. File something to get him heard before the court, and they can zoom in from the Wayne County Jail and we'll resolve it that way. But until he turns himself in, he's got a warrant out for his arrest. He's had this warrant out for I don't know how long. I can look back into the record, but and he's never presented himself. So he was contemptuous then. He continues to not follow or obey the court's orders. So he has to go do the time. Or hire himself a lawyer to get it back in front of the court. But until we get the first matter resolved that we had, we're not going to get into the other matters.
The contempt proceedings arise out of these, his appearance in court. So he's still not allowed to just resolve these before he commits himself to the Wayne County Jail?
No.
Honestly, I think the judge's approach makes perfect sense. During his first appearance, his behavior was noticeably dismissive and unnecessarily confrontational, which didn't earn him any goodwill with the court. When someone chooses to ignore basic courtroom expectations, it becomes difficult to justify offering any additional leniency. Judge Perkins' stance is clear and entirely reasonable. The 30-day jail sentence must be completed before anything else can move forward. It's a consequence that stems directly from his own actions, and the judge is simply enforcing what was already ordered. And truthfully, the original matter should have been resolved long ago. This entire situation could have been behind him more than a year ago if he had just complied with the standard process. Instead, every delay has only made a simple issue far more complicated than it ever needed to be.
Okay, Mr. Lockhart, join the breakout room.
And that'll conclude it. I still see Mr. Lockhart here. I don't know what else to do. What else you can do for him, Mrs. Harris?
So, Your Honor,
He continues to disobey the court order. Just continues to do so.
Your Honor, I dare not say. Well, I don't know. I don't think that it's an intentional, oh, I can't
That's
say
not
that.
intentional.
I
Wait a
can't-
minute.
I don't
So
think,
you
I'm
got-
gonna
All
take that
right.
back. I'm gonna take that
Oh.
back. I think he has good intentions. I think he now has a better understanding of everything that is taking place.
I don't think so, because he came in here talking about he's appearing on behalf of the person Jameer Lockhart. So I think he's on the same path as he was that got him into this situation.
In situations like this, there's a phrase we often use, the path where progress never really happens. It's the kind of pattern where someone appears to move forward, only to immediately undo their own progress with decisions that set them even further back. That it's a cycle we see often in cases involving individuals who insist on using unconventional legal theories that hold no weight in court. Every step toward resolution is followed by choices that complicate the matter all over again. So instead of advancing, they end up stuck in a loop of their own making, constantly reversing any small amount of progress they manage to achieve.
Had that discussion at length in the breakout room. He understands what it would take to resolve his matters. He understands how he has to represent himself in court. And so I think he's in a position that he wants to resolve these matters. We've had the discussion. We asked for leniency and mercy from the court. I understand if the condition is that he still has to do 30 days in the Wayne County Jail, although we would ask if the court would reconsider that sentence now that he has taken the time to actually listen to advice of counsel and be made fully aware of how he should present himself in court. I know that it's his intention to resolve these matters without any further court appearances or draining any further resources or delaying the process anymore. And I know that the court doesn't want to delay the process any further. I understand his behavior is what put us in this position as of right now, but we're just hoping to resolve today if the court will allow.
I'm not moving. I gave him ample, this is a 27 plus, maybe 30 plus minute video. I gave him ample opportunity. You know, and I'm not moving.
I mean, Your Honor, I mean, in that video, I did apologize to you for, I guess.
You apologize after you got the 30 days.
It's interesting how quickly an apology appears when the reality of a 30-day jail sentence becomes unavoidable. The moment it became clear that time behind bars was no longer just a possibility but an immediate consequence, the regret suddenly surfaced. But genuine remorse is shown through actions, not just words spoken in a moment of pressure. If he had truly intended to take responsibility for the behavior that led to the contempt finding, he would have turned himself in right away and completed the sentence as ordered. Taking accountability early on would have demonstrated sincerity and maturity, and it would have brought him one step closer to resolving his case instead of prolonging it even further.
I'm not
I
moving.
apologize after the offense was, I mean, I don't know when else I would apologize.
It's not, and you still haven't showed up, and it's been over a year, and now you want me to have some sympathy for you and to resolve the matters. I have no sympathy for you at all.
Mm-hmm.
I tried to discuss, we tried to give you a fair opportunity to be heard. You keep spewing these legal theories that I've never heard of before. And I'm giving you an opportunity at that date to speak with the lawyer. You refuse that. You refuse all the opportunities I've given you. And you came in here another time a couple of months ago, and I told you we weren't going to hear it then. You got to go report to the Wayne County Jail.
Mm-hmm.
So
I mean,
you've had ample opportunity.
You'd have me go to jail.
No, on behalf of Jameel Lockhart, I do understand that, and I know the court he may hear this often, but he does have a family that he supports. It would be a great hardship on his family, his resources, and his sense of economy in terms of his job if he would have to submit himself to 30 days in the Wayne County.
Looking back, This is one of those situations where a little foresight would have gone a long way. The choices he made in court were impulsive and unnecessary, and they set the entire problem in motion. Had he taken the proceedings seriously from the beginning, none of this would have escalated the way it did. And as for the special appearance he insisted on making, it clearly became his top priority, at least in his own mind, overshadowing any personal or family matters he claimed to be dealing with. The truth is, addressing the court properly should have been his main focus if he wanted to avoid these consequences that in the end, the court expects every participant to show respect, follow procedure, and handle their responsibilities. When someone chooses not to, the outcome is almost always the same: more complications, more delays, and more consequences that could have easily been avoided.
I understand that the court is not inclined to change that.
I didn't just give him the 30 days on the, he should have thought about that when I was asking him. I let him speak when I was asking him to not try to overtalk the court. Let me give him an opportunity to speak. He continued to disobey that. He should have thought about that then. There's a whole lot of people up in the penitentiary that have families that they take care of, and he's not going to the penitentiary. It's just county jail. So I'm just not moved.
Would this court consider amending it in such a way that he could only do weekends to complete his 30 days?
He hasn't even come to done anything. I'm not inclined to do anything for Mr. Jameer Lockhart or the person of Jameer Lockhart or whatever he wants to be called or however he wants to be described himself. Jameel Lockhart.
So yeah, he has the matters that are set on the docket for today. He has presented himself to the court today.
Okay, you want to take? We'll take off the warrant. We'll give him a pre-trial date, and then he can go do his 30 days. And he can tell the sheriff in there that what his next court date is, and they can, or somebody can writ him out then. City of Detroit versus Jameel Amir Lockhart, case numbers SP 1247989, counts 1, 2, and 3. State of Michigan. Now the laws just don't apply to him. State of Michigan versus Jameel Amir Lockhart, case number SX 378-29611. Appearance for the record, please.
Sherika Harris, on behalf of Jameel Lockhart, sir, could you state the name of the person that you are representing on the record, please, or that you identify, please?
So my name is Jameel Lockhart.
Currently, a recommendation if the court would allow a plea.
No. He's gonna have to go do the time.
So, sir, as we discussed, I think you would be better suited if you, 1, hire an attorney, 2, go to the Wayne County Jail and submit yourself so that your matters could be resolved. I understand that when you appear in court, there's different attorneys.
He didn't want an attorney. And I guess you have gotten through to him a little bit. He changed it. He came in here appearing on behalf of the person, Jameel Lockhart. And then when he asked him to state his name, he came and he indicated that he was Jameel Lockhart now. So I don't know what he like I say.
I mean, if I could speak a little bit here. I don't know, Your Honor, I'm not a criminal. I just want to handle this, get this over with.
I didn't say you were a criminal, sir. I didn't listen.
No, I know you didn't.
I didn't say you were a criminal. As it stands now, these are allegations. So until there's an adjudication of either guilt or not guilt, that'll determine, whether you're a criminal or not. So I don't know. You got these allegations out here. So I didn't make that comment. You were a criminal.
Right, right. No, I'm not saying that you did. But I just want to handle this and, put this to rest. At this point, I feel like it's taken up too much of my time, too much of, your time, I'm sure.
It always amazes me how uncomfortable some of these individuals become when they are simply asked to state their name for the record. A basic question that takes most people 2 seconds suddenly becomes a dramatic moment, as if speaking straightforwardly is the most difficult task in the world, that it's almost as though acknowledging their legal identity feels like an internal battle they are determined not to lose. Instead of just answering the judge, they tense up, overthink every word, and turn a routine formality into a full-blown performance. Watching that kind of reaction really shows how deeply they resist even the simplest parts of courtroom procedure, and how much stress they put on themselves in the process.
And,
this is what I do every day, sir. I serve the city residents of the city of Detroit and the state of Michigan and whoever comes in here. So it doesn't take up my time. This is what we do.
Yeah. And continuing, I would just like to, get this over with, pay whatever fines need to be paid. I would like to have my license back. I can't rent a car when I travel. I would like to be able to do that. So,
have you ever stopped to think about what the judge actually does for a living? This is his profession, and right now he's being paid to uphold the law and manage the courtroom efficiently, not to engage in theatrics or tolerate unnecessary disruptions. That if anyone deserves an apology here, it's not just the court staff or opposing parties, it's the taxpayers of Michigan. Their hard-earned money funds these proceedings, and when someone deliberately drags out or mocks the process, it wastes resources that could be better spent elsewhere. Respecting the system and following the rules isn't just about avoiding consequences. It's about honoring the responsibility that everyone in the courtroom shares, including those footing the bill.
Whatever I owe for these civil offenses.
Last year, over a year and a half ago.
Mm-hmm. Okay. I just want to resolve this. Whatever I owe for those offenses, I'm willing to pay, and it'll be done with this situation. I truthfully don't think it's your, mission to put people in jail that have not harmed anybody or committed any offense against, any actual live human being. I'm only guilty of speaking out of turn. And, I should have handled this differently. I can see that now, I really just want to get this whole situation rectified, and whatever the charges are that I need to pay, I'm willing to do that, and I'll put this to rest.
It's interesting how quickly priorities shift once real-life responsibilities begin to close in. After spending so much time rejecting the system, now that those choices are affecting everyday life, suddenly the idea of cooperating with the state doesn't seem so unacceptable anymore. Now that sight and doors have closed because of past decisions, the need for a valid driver's license and the ability to travel freely has become much more important to him. It's a reminder that no matter what someone claims in theory, reality has a way of pressing the issue to the end of the day. Participating in the proper legal process isn't about giving up control. It's about ensuring you can function normally without barriers you created for yourself.
Yeah,
Well,
based on the statements.
That being said, I don't think, based on everything that has happened, our history, the claim in federal court that I have.
This isn't a situation where you get to sit back, relax, and look at it casually as if nothing happened. Courtroom actions carry real weight, and ignoring the rules or causing disruptions doesn't come without consequences. Being disrespectful or uncooperative in court triggers a chain of accountability, and in this case, that accountability comes in the form of a 30-day jail sentence. It's a reminder that choices made in front of a judge have immediate and tangible repercussions. No amount of casual reflection or after-the-fact regret changes what was already set in motion. The court is clear. Actions have consequences, and now those consequences must be fulfilled before anything else can proceed.
In judicial tenure complaints that I have against you, I think you have a duty to recuse yourself from any of my cases.
I haven't been privy to any judicial tenure complaint. My first duty is the duty to sit, I feel that I
put it in your mailbox.
Okay, well, all right. Well, the Judicial Tenure Commission will have to come, and I'll have to respond to them accordingly if they present something to me.
Okay.
All right. Have a great day, sir. Next court date, 9/22. You're still expected to turn yourself into the Wayne County Jail.
Well, Your Honor, I would ask one final argument. I understand that he may have indicated he did not want an attorney to represent him. Jail time is a very harsh penalty. And I know that the court didn't just immediately come to that decision. I would ask if the court would consider some of the things that were stated on the record in terms of he now has a better understanding. He is remorseful of how things played out. And I would ask if the court would issue a monetary fine for the contempt rather than jail. If the court, please.
And he's got a proceeding in federal court against him. So where is it, where is this,
I'm simply trying to protect.
Your Honor, but again, Your Honor, Mr. Lockhart, on behalf of Mr. Lockhart, stop. What I'm saying, the court has to understand the fact that a lot of these things came into play before today. So if in fact there was something filed, it was before today, before having a better understanding of how the process works, how to conduct oneself in court, and that one is held to the same standards as an attorney. I would ask if the court would consider converting that jail term into a monetary fine.
Not at this point.
Your Honor, I only have a federal claim against you as a means to try to keep myself out of jail.
I've encountered plenty of questionable decisions in past cases, but this situation truly stands out. It's as if he hasn't fully grasped the fact that everything said in a courtroom, or even about a courtroom matter, is recorded, documented, and ready to be reviewed at any time. What makes it even more surprising is that he openly stated on video that he wasn't pursuing any civil claim or seeking compensation for anything the judge may have allegedly done. Instead, he admitted that the only motivation behind his statements was to avoid serving jail time, and that's a major problem. If the judge were to simply replay that clip, it could instantly undermine his entire argument. It shows that the claims weren't about justice or harm. They were about dodging consequences that had already been ordered that in the eyes of the court. That kind of contradiction can instantly unravel whatever strategy he thought he had, leaving his position even weaker than before.
Right? It's not something that I want to do.
You can take any action. You can take any action under the law that you choose to, sir. I haven't prevented you or even tried to even attempt to prevent you, and I can't prevent you from doing it.
I don't want to do that. I just want to handle this, pay whatever I need to pay, and move on.
Again, advocating on behalf of
needs to be sitting in jail. I'm an upstanding individual. I have a lot of people that depend on me, and I haven't harmed anyone, and I never would.
Understood. Thank you for that allocation. But on behalf of defense would now move to ask if the court would allow a hearing on the contempt proceedings.
That hearing has sailed. He has been gone. He has 30 days for the hearing. Procedurally, that has sailed a long time ago.
So he already had a hearing on it?
No, we asked him, offered a hearing on that. We offered him an attorney on that before we entered into found him in contempt. We offered him to speak with the lawyer on that day. He chose not to. It's been over, I would say, quite frankly, a year at least. The motion he mentioned, he was gonna file a motion by 5/27/2022. It's been a long time. Those ships have sailed.
But Your Honor, arguably, he didn't have the assistance of counsel. So I would ask, did we go through all of the steps for him to waive his right to counsel in that type of proceeding?
Well, you can go back and look at the transcript. If he wants some representation now, he can either have a court-appointed a lawyer, or he can hire a lawyer on his own. But at this juncture, I'm not inclined, you know, I get people tell me I'm too lenient and I'm a defense judge, and I try to be fair to everybody that comes through here. I gave Mr. Lockhart, and I'm giving Mr. Lockhart now over a half hour when other people only get 5 minutes to speak. I gave him ample time today and back when he came in court the last time. And you say that he's changed, but he came into court today spewing the same stuff that he started out before he talked to you, that he did when he was there. I read those motions that he filed, which was in the court's eyes had no basis in law whatsoever. None. I've never seen those legal theories that he's purporting. I don't know if you, well, let me strike that. I've seen those legal theories that he's purported, but I've never seen those in the rules of court rules. I've never seen that in any of the law books that I've ever read. So I told him this back then, that he needs to go get the rules. I gave him an opportunity to read the rules of procedure. He refused everything. Now, the transcript of it, you can order the transcript. He can hire his own lawyer, and he'll get whatever kind of hearing that he will get. I'm not going to recuse myself from the case.
Understood, Your Honor.
Okay.
I have nothing further.
Very well. Next court date, September 22nd, 2023, will be a pretrial. Have a very good day, sir. And again, you're ordered to turn yourself into the Wayne County Jail.